We are now seeing what Donald Trump's plan is to cover up the Epstein files, to cover up his dark past, notwithstanding the law that requires the Epstein files to be released in 30 days. So we're seeing two things develop right now, and I'm sure we'll see more, but I want to cue you in on what Trump and his DOJ are doing to try to avoid producing these Epstein files and avoid information coming out. So the first thing, Trump is coordinating with Ghislaine Maxwell and Ghislaine Maxwell's lawyer so that Ghislaine will invoke her Fifth Amendment right against self-incrimination and no longer testify before Congress. She previously delayed her deposition that was supposed to take place in August, saying she was appealing to the Supreme Court. She lost that appeal. Now she's still going to say she wants to invoke her Fifth Amendment right because she's going to assert what's called a habeas corpus petition, that she found new information that she needs to assert to get a new trial. The new information she's going to assert is that Donald Trump and others in the regime said this is all one big hoax, which she's now going to use to try to invoke the Fifth and reopen her case. So that's one thing that's happening. And also the MAGA Republicans in the House of Representatives are complicit in that because they're saying, why would we even take Elaine Maxwell's deposition to the minimum security facility in Texas if she's going to invoke her Fifth Amendment right? It'd be a waste of taxpayer dollars to even talk to her and get her on video while she invokes the Fifth. Nope, we need to get her on video and see her invoke the Fifth if that's what she's going to do, because she spoke to Donald Trump's former personal lawyer, turn number two at the DOJ, the Deputy Attorney General Todd Blanche, and she lied through her teeth every step of the way. What else would we expect with a convicted child sex trafficker and lifelong liar in Ghislaine Maxwell and Donald Trump's former best bud who's angling for a pardon? So that's number one. I've talked about that before, but here's what else is taking shape right now. So on Friday, and this didn't really get picked up anywhere in any meaningful way, or no one really made the right connections, the Department of Justice filed a renewed expedited motion to unseal grand jury transcripts relating to Ghislaine Maxwell and Epstein. So they filed first in the federal court in the Southern District of Florida. They will soon be filing most likely in the federal courts in New York. Previously, when the DOJ sought the grand jury transcripts relating to Epstein and Ghislaine, all three courts, because there were grand jury proceedings in Florida and two in New York, all three judges denied turning over the grand jury transcripts because it's against the law under Federal Rule 6, which is the rule regarding grand jury secrecy, to turn over this testimony. And all of the judges in their orders, which I'll go over for you in a moment, they all said, we're not sure why you as the DOJ are asking us for the grand jury transcripts. Number one, federal courts are not allowed to turn that over. You should know that, DOJ. But number two, these grand jury transcripts just related to a single FBI agent who testified for a very short period of time, who did not have any real meaningful involvement in the case. And this was mostly things that were already public knowledge based on what happened in the trial. This isn't the files. And what the federal judges said is that you have the terabytes and terabytes of information. Turn over those files. Why are you asking the federal judge to turn over grand jury transcripts, which involve grand jury secrecy issues, when it's not even new material? So why would we turn this over anyway? You have all of the information. So the federal courts all rejected this idea of turning over the grand jury transcripts because it's against grand jury secrecy. So now what the DOJ is doing, and this is part of their delay tactics, they now went back to the federal courts and they said, look, we've got this law. It's called the Epstein Transparency Act. Trump signed it into law. Now can you please turn over the grand jury transcripts? The Epstein Transparency Act has nothing to do with the grand jury transcripts, but what the DOJ is going to want to do, it's the sleight of hand. They're hoping that you don't know the way the law works. So they're going to say, well, look, we asked the federal judges to release the grand jury transcripts yet again, and we were denied. So we're fighting for our ability to get it released, and the courts aren't releasing it. And of course, we know these aren't the Epstein files, right? I mean, they want us to believe that the court has the Epstein file. The grand jury transcript is going to be 50 pages, 60 pages of an FBI agent testifying to hearsay that just involves the charges against Ghislaine and Jeffrey Epstein that everybody knows publicly because they were charged publicly. So I think it's important to point out that that's one of the plans that the DOJ has. And then I think when the federal judges deny it and say they don't have the legal power to turn it over, then the DOJ is going to maybe try to appeal that, maybe go to the Supreme Court. Hopefully this causes, in their view, not hopefully for us, but what the DOJ is planning, maybe they can stretch this out for a few months, a year, and then delay. And ultimately, if they're denied, they're going to say, see, that becomes precedent for why we can't turn over the Epstein files because the federal judges said they can't turn over the grand jury transcripts. So if we have to interpret the law, the Epstein Transparency Act, the federal courts are telling us that they can't turn over the transcripts, so we can't turn over the files. That makes zero sense, though, and they're relying on people not knowing the way the law works because they're going to try to throw these judges under the bus. You see what I'm saying? So what we have to realize is, no, the grand jury transcripts are not the files. They're not even a fraction of a fraction of a fraction. It's just some FBI agent who testified against Ghislaine and Jeffrey Epstein, but had no clue and did not testify about all the other men, the financial transactions. That had nothing to do with the grand jury, which is going to be, an hour or so in length. So let me just go through these filings so you actually can hear what's going on, because I want to cue you into the plan so we get ahead of what the Trump fascist DOJ regime is doing right here. Okay, take a look right here. This is what was just filed. You see, it was filed November 21, 2025. United States District Court, Southern District of Florida, United States expedited motion to unseal grand jury transcripts and modify protective order. It's like, why are you doing that? The DOJ, you have the terabytes of Epstein files. And y'all realize when I say terabytes, that means the DOJ has enough files that if you were to print them all out, right, they're electronically stored, they could fill up massive skyscrapers, like many massive skyscrapers. And they have audio and they have video and they have surveillance footage and they have wiretaps in addition to the emails, right? Think about the Epstein email estate, the Epstein estate email dump that was done like last week or 2 weeks ago, right? 23,000 emails. 23,000 emails compared to terabytes would be like a very, very small amount. Like it's not even close. So we want the information, and the DOJ is trying to say, no, we want the grand jury transcripts. We don't care about the grand jury. Why we don't want those? Give us the Epstein files in your custody and control. So here's what the DOJ says. At the direction of the Attorney General, the Department of Justice files this expedited motion asking the court to unseal the grand jury transcripts and to modify any protective order associated with the grand jury investigation referenced above. The Department of Justice previously petitioned the court to unseal the grand jury transcripts associated with the above referenced grand jury investigations because of extensive public interest regarding the basis for conclusions in a July 6, 2025 memorandum. The court denied the petition, concluding that neither Federal Rule of Criminal Procedure 6E nor precedent authorized unsealing the grand jury materials. After the court entered its order, Congress nearly unanimously passed and the president signed into law the Epstein Files Transparency Act on November 19, 2025. Subject to certain enumerated exceptions, the act requires the Attorney General no later than 30 days after enactment to make publicly available all unclassified records, documents, communications, and investigative materials in the possession of the Department of Justice, including the Federal Bureau of Investigation and the United States Attorney's Office, that relates to 9 topics such as Jeffrey Epstein and Ghislaine Maxwell. Okay, so what does that have to do with the court's grand jury transcripts? You need to produce, Pam Bondi, what's in your custody and control. But do you see how they're trying to now shift the burden to the court and basically say, this is the court's fault? And then they go on and say, in light of the act's clear mandate, the court should authorize the Department of Justice to release the grand jury transcripts and lift any pre-existing protective orders that would otherwise prevent disclosure. To the extent permitted by the act, the Department of Justice will work with the relevant United States Attorney's Office to make appropriate redactions of victim-related and other personal identifying information. Because of the Act's 30-day deadline, the Department of Justice requests an expedited ruling on this motion. And the court's likely going to look at them and say, what are you talking about? This is not what the act says. The act says turn over the files in your custody and control. Why are you going to the court? If you have the files, turn the files over. Let me just show you and explain to you what the courts have said before. Because as I've said previously, 3 federal courts rejected previously over the summer when the Trump regime tried to do this. So let's take a look right now at what Judge Richard Berman, he's a federal judge in New York, who was presented with the same issue by the DOJ. And here's what he said. He says, the government is seeking this disclosure. It's unusual for the government to seek to unseal grand jury material. A significant and compelling reason to reject the government's position in this litigation is that the government has already undertaken a comprehensive investigation into the Epstein case and, not surprisingly, has assembled a trove of Epstein documents, interviews, and exhibits. And the government committed that it would share the Epstein investigation materials with the public. And then it goes on and cites what the Attorney General had previously said. The government's 100,000 pages of Epstein files and materials dwarf the 70-odd pages of Epstein grand jury materials. The government's Epstein files are, it says, sui generis. They are investigatory and not subject to the federal rule of criminal procedure 6E. The government is the logical party to make comprehensive disclosure to the public of the Epstein files. By comparison, the instant grand jury motion appears to be a diversion from the breadth and scope of the Epstein files in the government's possession. The grand jury's testimony is merely a hearsay snippet of Jeffrey Epstein's alleged conduct. That's why here on the Midas Touch Network, I read from the court opinions so you can hear what the federal judges are saying, that this is a diversion and the grand jury testimony is a hearsay snippet. The agent doesn't even have direct knowledge versus the actual underlying documents.
You know, it's wild. We talk all the time about heart health, gut health, brain health, but almost never about the most underrated organ in your